I will then proceed and in summary just add the following before pronouncing the sentence, is that we should also keep in mind the magnitude of the offense that the accused has been convicted of. We've heard daily or weekly of children playing in their front yards in the street who are caught in crossfire, random shots fired, killing people. It's just the first time that we hear it's being called celebratory shots. And in essence, the accused, all as stated, are equal before law. But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this. You may please stand up. Not the court only. Sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can show you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated. Thank you. May we, Advocate Otis, sorry not to interrupt you, may we just deal with the Section 103 inquiry and then we can proceed to that part. I assume you are ready for that part as soon as we've dealt with the 103 inquiry. Certainly. Okay. Let me just find my notes here. Just as a brief explanation to unless it's not clear, the next step after sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances. And the inquiry in terms of Section 103.1 Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103, subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So Advocate Holders? No submissions. Thank you. Advocate Caesar, on behalf of the state? Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit, and it is followed by the following further order by court. That Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization, and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations and permits issued to him or her in terms of this Act, all firearms in his or her possession and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act. Okay. All right. So what we are left with is the application. Are you ready to proceed now? Okay. Let me just get that part of it ready. I'll be with you now. Yes. Just a minute, Advocate Holders. I just want to quickly grab the notepad. I haven't drafted that, so I'll have to listen to you carefully here. Just a minute. Okay. Thank you. Yeah, I'm ready.
An application for leave to appeal to the High Court of South Africa, East Cape Division, held at Grahamstown, against the arm of the judgment convicting the accused of firstly unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Narinko rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act 60 of 2000, to wit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or transit license, or other authorization third count, Your Worship, is unlawful discharge of a firearm in a built-up area or any other place in contravention of Section 120 sub 7 of the Firearms Control Act 60 of 2000, to wit the CSIP, the Kashi Stadium in Lansani. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to personal property in contravention of Section 120 sub 3 sub C of the Firearms Control Act 60 of 2000, and that the accused of control of a loaded firearm, to wit a .223 Marinka rifle, and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public, attending the 5th Economic Freedom Fighters celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub B of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handled the firearm, to wit a .223 Narinka rifle, and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the Economic Freedom Fighters celebration, residents of Mdansani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, the residents of Mdansani and Gear House employees. Your Worship, this application for leave to appeal is based upon the following grounds of fact and law. Firstly, this is in relation to the convictions, Your Worship. In assessing the evidence, having acknowledged that the court was obliged to evaluate circumstantial evidence in this matter, the court had regarded to the often quoted dictum in Rex v. Blom and held that there are two cardinal rules of logic which cannot be ignored. And there's a quote from Your Worship. There are firstly that the inferences sought to be drawn must be consistent with all the proved facts, and secondly the proved facts should be such, and Your Worship said, I quote, that they exclude every reasonable inference from them save the one sought to be drawn. Yet, we say, Your Worship, that Your Worship, the magistrate, committed a material misdirection, not having any alternatively sufficient regard to all of the facts that militated against the guilt of the appellant, of the accused at this stage, Your Worship. We say that this occurred despite, Your Worship, the magistrate having held, and there's a quote here, Your Worship, the court must not take each circumstance separately and give the accused the benefit of any reasonable doubt as the inference to be drawn to each one so taken. It must carefully weigh the cumulative effect of all of them together, and it is only after it that it has been done so that the accused is entitled to the benefit of any reasonable doubt which it may have as to whether the inference of guilt is the only inference which can be reasonably drawn. To put this matter in another way, the state must then, as stated, satisfy the court that each separate fact is, let me rephrase as stated, the state must satisfy the court not that each separate fact is inconsistent with the innocence of the accused, but the evidence as a whole is beyond reasonable doubt inconsistent with such evidence. Yet we submit that Your Worship committed a material misdirection, not having any alternatively sufficient regard to all of the facts that militated against the guilt of the accused. In this regard, we say further that Your Worship further erred in holding that, and there's a quote, a number of circumstances, each individually very slight, may so tally with and confirm each other as to leave no room for doubt of the fact which they tend to establish, though each taken by itself, but as light as a feather, however, join them together, you'll find them pressing on an individual with the weight of a millstone. And we say that you further erred in this regard, Your Worship, when you held. It is further described that in cases surrounding circumstantial evidence and circumstantial evidence alone, evidence varies infinitely in its strength in proportion to the character, to the variety, to the independence one of another, and one might describe it as a network of facts cast around an accused person. That network may be that strong as it is in part, and it may also leave gaps and may then allow the accused person safe passage. It may be so close, so stringent, so coherent in its texture that no efforts on the part of the accused can break through. It may also come to nothing, and or on the other hand, it may be absolutely convincing. The law does not command that you should act upon certainties alone. We often ought to act upon just and reasonable convictions founded upon just and reasonable grounds. The law asks for no more and the law demands no less. I further refer to State v. Kwanda, 2013, 1 SSCR 137, Supreme Court of Appeal, where Mareja stated that such an inference is only justified where the state has established facts from it can properly be inferred by a court. We say the court mentioned but only paid mere lip service to the issues raised in argument on the merits on behalf of the accused, did not have sufficient or due regard thereto. In this regard, the court mentioned the 23 statements by the investigating officer, Colonel Swartboy, the lack of DNA or fingerprints linking the accused to the firearm, no eyewitness complaint, and various other factors relating to a 9mm Glock firearm and ammunition. However, the court did not take these factors into account in its application of the two cardinal rules relating to the admission of circumstantial evidence. We go further, Your Worship. We say, additionally, the court's assessment of the circumstantial evidence and acceptance thereof did not have regard to the absence of any damage to any structure and the inability to link the suspected firearm and spent cartridge to the accused. Other significant factors in this regard were that no person reacted in fear, and the 5 VIP SAPS members had not witnessed any shooting.
I'm sorry, if you can just mark there where you are busy with. She's informing me that there's a sound coming that she needs to check from our court recording machine, and I just please don't want anything to go wrong with our recording of the stage of the proceeding. So she's asking that we just adjourn for her to check and that all cables etc. are in place. I'll just leave, please. I'm not going to pack up everything, just leave it here, and then I'll be, when you're ready, they'll indicate to the police and I'll enter. Thank you.